Welcome, everyone. This is the House Committee on Judiciary and Hawaiian Affairs. It is Thursday, March 2nd, 2 p.m. We are here in conference room 325 at the State Capitol. My name is David Tarnas. I'm chair of the committee. Vice Chair Greg Takayama is here, and our member, Representative Kanani Souza. Other members will be with us presently. We've got a number of very interesting bills on our agenda today. Last agenda before crossover. Before we get started, I'd like to request those who are testifying here and on Zoom, no one's on Zoom? The monitor's not on. Those who are testifying here and on Zoom, if you would please limit your testimony to 2 minutes, and then at that point I'll ask you to summarize. That way we have a chance for hearing every testifier and chance to ask questions and deliberate. If you're testifying via Zoom, then please, while you're waiting, please keep yourself muted and your video off. And then when I call your name, unmute yourself, turn your camera on, and provide your testimony. And then after you're finished with your testimony, turn off your video and your microphone. If you have technical issues, please use the Zoom chat function and communicate with the technical staff. If you're disconnected unexpectedly, don't panic. Just try to get back on the internet, rejoin, and then I'll try to fit you in so you can provide your testimony when you return. If we lose power here in the Capitol and we have to reschedule it, don't worry, we will schedule a meeting for decision making if we're able to in the legislative and meet the legislative schedule, and we'll post appropriate notice. If you're testifying by Zoom, please don't use trademarked or copyrighted images behind you, because that gives us trouble with YouTube, because they bump us off and that's no good. So please help us out. And then everyone who's testifying, please refrain from profanity or uncivil behavior. We're all allies here trying to help each other do what's best for the people of Hawaii. So I appreciate everyone's kokua. Okay, let's go forward now on to our bills and consider the first bill, House Bill 758, relating to Native Hawaiian traditional and customary fishing practices. Authorizes the Department of Land and Natural Resources to issue special activity permits for the purpose of recognizing and protecting individuals exercising their Native Hawaiian traditional and customary rights. First up, we have testimony from the Department of Land and Natural Resources. Mr. Brian Nielsen, welcome. Good to see you, sir.
Aloha, Chair, members of the committee. Brian Nielsen, representing Department of Land and Natural Resources. We stand on our written testimony and support, and we're available for any questions. Thank you.
Thank you. And as you may not have noticed in this committee, I always ask those who say they're going to stand on their testimony to summarize their testimony for those who are watching and haven't had a chance to read your testimony. So could you please explain why we should be supporting this measure?
Yeah, so basically this would provide an option, not a requirement for people who are interested in practicing their customary traditional practices and maybe wanting to carry out a practice that is a regulated species or gear type under Division of Aquatic Resources rules, and it may be subject for them to get a violation from DoCare. So this permit would provide an option to be able to avoid, that kind of potential interaction in trying to carry out their practice. But it's not a requirement; it's an option.
Thank you. And for those who are listening and don't know, DoCare is an abbreviation for the Division of Conservation and Resource Enforcement. In this committee, we really try not to use jargon or abbreviations because we want it to be in plain English so everyone understands. So no disrespect, but I'm just translating.
Thank you.
Yeah. Okay, thanks for that explanation about your testimony. Next, we have testimony in opposition from the Office of Hawaiian Affairs. Testimony in opposition from Godfrey Akaka, Native Hawaiian Gathering Rights Association. Testimony in opposition from Kenneth Conklin. Testimony in opposition from Steve Kaiser. Please proceed. Mr. Kaiser, if you're there, please unmute yourself, turn on your camera, and provide us your testimony. There you are.
Yep. Good morning. David, you look good in a suit.
Thank you, sir.
I'm all supportive for Hawaiian Native rights and being Hawaiian, but unfortunately, this leaves Duke here in a very dubious position. I mean, somebody's out there and they're claiming rights, but they're not Native Hawaiian? I mean, how is Duke here supposed to, respond to that? Hawaiians come in all different colors and flavors nowadays. So, one part of enforcement is to make it easy for the enforcement agent. So they go and stop somebody who's exercising his rights, and he said, and maybe he's not Hawaiian. So I would just be cautious. I think it would be better to lose the last part, that section on page 411 through 15, and I don't think, most Hawaiians, I think it would be proud to have a permit saying that they're Hawaiian and they can practice their Native Hawaiians rights. We're not trying to stop anybody. We're just trying to clarify who these people are. Thank you very much.
Thank you very much. Next, we have testimony in opposition from Dana Keave, La'a Poipoi, and James Pirtle. Is there anyone else here wishing to testify on House Bill 758? No? Okay. If not, questions, members? I have a question, if not, DLNR?
Yes, Chair.
In your testimony, you refer to gathering. Is gathering considered fishing?
It could be considered fishing.
Under
yes.
the law?
Yes, is that, yes.
Okay, just checking on that. If you could please explain to me, clearly the Office of Hawaiian Affairs has opposed this in the past. I know I had communicated with you asking you to confer with them to try to explain your situation. If you read their testimony, I'm going to briefly quote from it, saying, OHA takes care to note that the Department of Land and Natural Resources had reached out to meet on the issues at the core of this measure, and both agencies will continue to work together to address these issues to advance our mutual interests. And then they proceed to say why they oppose the bill and want us to defer it or hold the measure. Could you briefly explain what has been your conversation so far, and what will you do moving forward to communicate and collaborate with the Office of Hawaiian Affairs on this matter?
Yes, so the division did reach out to Office of Hawaiian Affairs. Myself and David Sakota met with them twice. Actually, David met with them twice. I would just joined one of the meetings. We discussed their concerns, and they raised some very valid concerns and considerations that we hadn't considered before. In terms of next steps, we continue to work with the Office of Hawaiian Affairs to, determine any issues that they may have with the bill.
Do you think that it would be helpful to have additional time to work with the Office of Hawaiian Affairs to try to address their concerns and achieve your goals, and then maybe come back next session with a bill that both parties could support? Absolutely,
yeah. That would be the best outcome if we can come up with some language that they can support and the division can support as well.
Okay, all right. Well, thank you very much.
Yeah.
Appreciate your efforts so far to this point, and thank you for that summary of your work so far.
Okay, thank you.
Thank you. Any other questions, members? If not, let's move on to the next measure. House Bill 760, relating to aquatic resources. This bill actually expands on the authority that we provided to the Department of Land and Natural Resources in previous sessions, and we expand upon their rulemaking authority to include any rule deemed necessary to protect certain aquatic life. It expands the Board of Land and Natural Resources authority to temporarily adopt, amend, or repeal certain natural resource rules by formal action at a publicly noticed meeting if the board finds that such adoption, amendment, or repeal is necessary to implement effective and adaptive management measures in response to new or previously benign aquatic nuisance species, in light of newly available technology, or in light of newly available data. It creates new fines for violation of rules pertaining to the department's prevention of or response to previously benign aquatic nuisance species. First up, we have testimony in support from the Department of Land and Natural Resources.
Thank you, Brian Nielsen, Division of Aquatic Resources. We stand on our testimony in support. Essentially, as Chair Tarnas, you described, we do have this adaptive management authority to respond to rapidly changing environmental conditions. So with this bill, we're looking to expand that authority to also be able to respond to new information, new technologies, new nuisance species, invasive species as well with under this authority. But it would again be publicly noticed. It would automatically sunset after 2 years. So there's still some guardrails on that authority, but it would allow the department to respond to different issues and threats as they come about.
Thank you. Thanks for that summary of your testimony. Next, we have testimony with comments from the Office of Hawaiian Affairs, testimony in support from the Environmental Caucus of the Democratic Party of Hawaii, and testimony in opposition from Steve Kaiser. Mr. Kaiser, please proceed.
I'm a bit unclear as to whether this only refers to invasive species, which I don't really see the language completely stated in there. It mentions invasive species, but it doesn't particularly rule out that this bill applying to any other types. And I have an issue with on page 5 it says 16 through 18. Any other restriction or crime deemed necessary, the department to implement the purpose of this thing. And then it goes on in page 6 to talk about in light of new technology or in light of newly available data. I was privy to a meeting a while back where it talked about the possibility of changing the transit studies that were used to determine fish populations into a new method, which would then subside. It would basically make all the other transits obsolete. So, you know, when you talk about measuring numbers of animals, the new technology could be referred to as lowering the numbers of fish, which would be unacceptable if you haven't followed the past technology that was used. New technology is great, but it then usurps it. I'll cite transit studies, also cite CPU, which is catch per unit efforts, is another measurement of numbers of animals. If you change the method you're using, your data basically could change also. So I'd be very cautious. I can't support this bill as written simply because it leaves just so many things open. And I wouldn't see, the other issue that I have is the wording to implement any other restriction or requirement as deemed necessary. I can't see that being applied, that language being applied to any other department except the DLNR. You certainly wouldn't use that for the Liquor Commission or public safety or anything else. That's a very, very broad term, which could, it concerns me. Thank you very much.
Thank you very much, Mr. Kaiser. Next, we have testimony and support from Bert Weeks. Is there anyone else here wishing to testify in House Bill 760? If not, questions, members? If not, I have a question for DLNR.
Yes, Chair.
You've discussed this measure with your Fishers Working Group, which, for those who don't know, it's an advisory group that the Department of Land and Natural Resources Aquatic Resources Division has assembled of people who are active fishers throughout the state. From my understanding is that their input helped you to develop this measure. And I think part of it was their skepticism about this being done in an arbitrary manner without input. Please explain to the committee how the public would be able to provide input on any of these proposed rule changes that could be promulgated through this new authority that you are seeking to get in this measure.
Yes, thank you, Chair. So we still would be required to take any change in rule through this authority to the Board of Land and Natural Resources that would need to be public noticed. So public could still provide testimony to the board, and the board would actually make the decision on whether to approve the recommendation to go with a change in rule through this authority.
Okay. And then the next question is following up on Mr. Kaiser's comments. Would one consider changes in the research methodology or survey methodology as being, new technology that might trigger the department or the division to propose new rules?
Yeah, I think just as we develop rules through our regular authorities, we rely on science, we rely on reason. So, changing a method, obviously you could get drastically different results. That wouldn't necessarily be a reason to come up with a rule. And again, we would have to make a reasonable case for whatever rule we're proposing to the land board, and they would be the ultimate decider. So I would hope they would, if there was a change in methodology, they would take that into consideration as to whether this request was reasonable.
So if you were to change the approach that you use to develop data, to do transects, to do counts of fish, to assess stocks, and you come up with a new estimate of, a maximum sustainable yield for the catch of that particular species, in your presentation to the board, you would actually have to explain why your new data is defensible and how it compares to the old data set that you used previous techniques for and assumptions for, and as scientifically explain how you can draw conclusions with your additional data set. Is that correct?
That's correct, and we would have to share, what type of error is associated with making that estimate as well. So if it's a new methodology, you only have a single point in time, and you'd probably have a lot of error in making any type of predictions about a certain population as well. So that would all need to be shared with the board.
Okay, and then one last question. Mr. Kaiser brings up the issue that page 5, lines 16 and 18, the bill states that any restriction or requirement as deemed necessary, and he's very skeptical about that. Could you give me some sense as to what your guardrails are in terms of what this might include?
Yeah, as we've been discussing, the land board's the ultimate decider. So, we have to make a reasonable case to the land board if something is reasonable and justified to create a temporary rule. But yeah, we also take input from the stakeholders that are affected by any rule as well. So I don't think we would go without reason and create a rule that was beyond our authority, beyond the evidence and scope of our management authority. But yeah, if the committee finds that they need additional guardrails, maybe that's some language that you want to take a look at.
Okay, thanks. And I understand Mr. Kaiser has joined your Fisher Worker Group?
Yes, he's one of our newest members of the Fishers Working Group. Yes,
he's from the Kohala district, and you need to have representation from there. So I'm glad that you've brought him on, and he's a very discerning and critical thinker. So I'm glad that you've got him to advise you.
Yep, and we appreciate his time. So
okay, thank you very much. Thank you. Are there any other questions, members? If not, we'll go on. Thank you to all the testifiers. Thank you for beaming in from Kohala, Mr. Kaiser. We're going to move on to the next measure. House Bill 975 relating to sustainable agriculture. It clarifies the requirements for the submission of applications and dispersal of grants under the cover crop reimbursement pilot program. First up, we have testimony in support from the Department of Agriculture. We're lucky to have the chairperson here. Welcome. The floor is yours. Please proceed.
Thank you, Chair, Vice Chair, members of the committee. Sharon Hurd, Department of Agriculture. The department supports this bill because it cleans up some of the unmentioned rules, details when the act passed last year. Specifically, it allows for the Attorney General to come up with specific rules for the application for the 75% reimbursement when you purchase seeds or green manure. Thank you.
Thank you very much. Next, we have testimony with comments from the State Procurement Office. For the members and for Department of Ag, I want to point out that the State Procurement Office is concerned that there is no mention in the bill of public posting to ensure eligible applicants have equal opportunity to participate in the 3-year cover crop reimbursement program. neither is there language to post any awards, which is normally done for all types of contract awards. The language also does not require for-profit entities, nonprofit community-based organizations, and cooperative associations be compliant with the laws of Hawaii, including, and they list several of them. So I just want to point that out to the members and to the public and all the testifiers, the concerns from the State Procurement Office. Okay, next we have testimony in support from Brian Miyamoto, Hawaii Farm Bureau. Welcome, Mr. Miyamoto. The floor is yours. Please proceed.
Good afternoon, Chair, Vice Chair, Representative Gannon. Brian Miyamoto here on behalf of the Hawaii Farm Bureau. You have a written testimony in support. As you heard the Chair of Department of Agriculture, this is a housekeeping measure. Legislature passed a very important cover crop program last year. We believe this measure is going to satisfy the legal criteria and standards for the distribution of the funds. So before we can roll out the program, we need some legal clarification. So thank you for the opportunity to testify.
Thank you very much. Next, we have testimony in support from Hunter Hevelin with the Hawaii Farmers Union United, testimony in support from Dana Keave, and from Carolyn Azelski. Is there anyone else here wishing to testify on House Bill 975? If not, questions, members? I have a question for the Department of Agriculture. I just read out the concerns from the State Procurement Office. Seems like they're very reasonable concerns that I think should be addressed in the measure. Does that make sense to you?
It absolutely makes sense. It's an oversight, Chair.
Okay, all right, thank you very much. Any other questions? If not, we'll move on. Thanks very much to the testifiers. Okay, next we're going to move on to House Bill 970, relating to agricultural lands. The bill makes technical changes to the statutory definitions of agricultural enterprise lands and non-agricultural park lands for clarification and consistency purposes. First up, we have testimony in support from the Hawaii Department of Agriculture. Chairperson, floor is yours. Please proceed.
Chair, Vice Chair, members of the committee, Sharon Hurd, Department of Agriculture. This is another housekeeping bill, Chair. It's to allow the department the ability to lease lands managed by the department for related agricultural activity rather than solely for crop development and production. That language inadvertently created an inconsistency with another portion of the rule in the definition of non-agricultural parklands, which is ranching, pasture lands, and this bill would correct that inconsistency.
Inconsistency with another part of the statute?
Yes.
Not the rule, okay.
Yeah.
Just making sure I understood. Thank you very
Thank you.
much. Next, we have testimony in support from the Hawaii Farm Bureau, Mr. Brian Miyamoto. Please proceed.
Thank you, Chair, Vice Chair, members of the committee. Brian Miyamoto here on behalf of the Hawaii Farm Bureau. Our testimony is, again, in support. This is another housekeeping administrative bill. I think the Chair had explained it. Quite frankly, it is inadvertently the bill that passed last year, which was great, inadvertently created inconsistencies with the definition of non-ag park lands in HRS 166E. So again, as the Chair said, this bill just remedies that inconsistency in the language. Thank you for the opportunity to testify.
Thank you very much, sir. Is there anyone else here wishing to testify on House Bill 970? If not, questions, members? Nope, seeing no questions, I think we'll move on. Thanks very much to the testifiers. Next, we have House Bill 841, relating to domestic abuse protective orders. This bill amends the automatic referral requirements to apply when there are allegations of child abuse and a domestic abuse restraining order is sought. First up, we have testimony in support from Matthew Viola, Judiciary. Next, we have testimony in support from the Department of Human Services. Next, we have testimony in support from Angelina Mercado, Hawaii State Coalition Against Domestic Violence. Next, we have testimony in support from Ryan Kusumoto, Parents and Children Together. Next, testimony in support from three individuals, Marilyn Yamamoto, Dana Keave, and Penelope McKenzie. Is there anyone else wishing to testify on House Bill 841? If not, questions, members? Okay, I think we're all set. We'll move forward to the next bill. House Bill 1201 relating to noise pollution establishes noise generated by helicopters in excess of a certain decibel level as a public nuisance and a source of noise pollution in violation of the state's noise pollution law. It establishes fines and a private right of action for individuals to sue helicopter owners and operators for creating a public nuisance. First up, we have testimony with comments from the Attorney General. Welcome. Please introduce yourself. The floor is yours.
Good afternoon, Chair Thomas, members of the committee. My name is Wade Hargrove. I'm a Deputy Attorney General. I'm here on behalf of the Attorney General's office. And I would just highlight the key thrust of the testimony, which is that it is unconstitutional, likely to be challenged pursuant to the Supremacy Clause of the United States Constitution. Congress has made it pretty clear that FAA regulates federal airspace, and the courts have elaborated on that, meaning that not just federal airspace, but of course the aircraft by way of an extension of the logical conclusion of their operation in federal airspace would include noise attributed to their operation. So we just wanted to highlight that that is a concern, and thank you. I'll be available for any questions if you have anything.
Thank you very much. Next, we have testimony and comments from the Department of Transportation. Welcome. Thanks for being here.
Thank you, Chair
Please
Thomas.
proceed.
Thank you, Vice Chair Takayama, members of the committee. I'm Tammy Lee, the Acting Deputy Director for the Department of Transportation. We stand on our written testimony providing comments to this measure. I'm available for any questions. Basically, we diddled the Attorney General's office. We know that federal law always trumps state law.
Understood. Thank you very much. Next, we have testimony in opposition from Christopher Reimer with Jack Harder Helicopters. Testimony in opposition from Jared Yoshiki, Aircraft Owners and Pilots Association, and testimony in support from Dana Keave. Is there anyone else here wishing to testify on House Bill 1201? If not, questions, members? I have a question for the Attorney General, Mr. Hargrove. I understand from your testimony that regulating air traffic is a federal jurisdiction. Is regulating noise within the state jurisdiction?
To be clear, I would be happy to explore this further at a later time. Off the cuff, I can tell you that my understanding of noise attributable to aircraft is that it is within the purview exclusively of the Federal Aviation Administration. I mean, one way to think of it is the federal government, by way of congressional act, tried to create a space for exclusivity so that we wouldn't have the kind of conflicts that arise. So, for example, if someone was trying to interfere with a scheduled flight that had been approved for departure arrival via a certain route over which the federal government has control, someone is concerned about the noise that's generated, you would have that potential for conflict between what the state, by way of its regulation of that noise, and the FAA's directive that the flight follow a certain path. So by virtue of the noise being inseparable from the aircraft, if you will, or the operation of the aircraft, state regulation would have to succumb to the federal preemption.
So does the state regulate noise from other sources?
We do, absolutely do.
But you are skeptical that we would have the authority to regulate noise emanating from an aircraft?
Well, only to the extent that it would have that necessary effect on the operation and flight path. I mean, you can't, as I understand it, there is just no way as a practical matter to separate the noise from the flight path, which is the concern. I mean, my understanding of the nature of the concern, the complaints related to the sound generated is the proximity.
Which would include flight path and altitude.
That's correct. Exactly. Both of which, of course, FAA regulates.
And the muffler system on the aircraft. And so, just so I'm
that's a
clear,
good question.
so the state government has authority to regulate noise, But there's some question, and I understand your off-the-cuff answer is that, but we don't have authority over noise emanating from aircraft because they're inseparable from that aircraft.
That's right. I mean, the federal government has exclusive jurisdiction and authority by way of Congress, and it's the preemption in federal laws related to aircraft. They exclusively have the right to regulate aircraft.
Understood. Okay.
So aircraft operation, safety, and flight paths.
Okay.
So that's.
So this bill is not asking the state to regulate the noise, but it would set a acceptable level of noise, but it gives a private right of action to the citizen to sue if that aircraft produces noise that exceeds that threshold. So it's not the state who's doing it, it's a private individual who would have the private right of action to sue. What is your sense of the private right of action if it were to, if there were a state law that sets that noise limit, that threshold, and then we authorize a private right of action for individuals to sue an entity that exceeds that threshold? So it's different, right?
Right. So if a private individual was to seek a remedy in court pursuant to the state law, it is our assessment that it's likely, more likely than not, highly likely given how clear the preemption language is in the statute and the cases that have interpreted have been, and that remedy will be foreclosed by the fact that the state law authorizing the pursuit of that remedy is unconstitutional. So, for example,
Okay.
that individual would fail in their effort to seek a change in the flight path, a change in the level of noise, something to that effect, fail to collect penalties under this statute as the bill's currently
That's right.
drafted. That's right. For the simple reason that the court would not acknowledge that right exists because the law would be invalid.
Okay. I think it's an innovative approach this bill takes, and so, but I appreciate your opinions on that. Thank you very much. I appreciate that. Any other questions, members? If not, thank you very much, sir.
Thank you.
Appreciate it. Thank you, Mr. Hargrove. Okay, anyone else wishing to ask questions on this? If not, we will move on to the next measure.
So irritating.
House Bill 1398 relating to collective bargaining. This bill allows telecommunications and emergency dispatchers and employees who perform similar functions employed by the state and counties to collectively bargain. First up, we have testimony from the Department of Human Resource Development. The director is here. Thank you very much for being here. The floor is yours. Please proceed.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Brenna Hashimoto. I'm actually here in my capacity as the Chief Negotiator. And while we appreciate the intent of this measure, we have to respectfully oppose it for several reasons. First of all, it's unclear, the measure is unclear as to whether this seeks to only move employees that are currently in Unit 3 into this new bargaining Unit 16. Currently, across all jurisdictions, there are about 5 different bargaining units that have employees that perform telecommunications and emergency dispatch work. And so that part is unclear to us. Secondly, we believe that this bargaining unit has been mischaracterized as only being clerical staff, when in fact Unit 3 also includes all non-supervisory employees in white-collar position, which includes both all clerical, technical, and paraprofessional jobs. And lastly, a study was conducted in pursuant to Act 63 and Session Laws of Hawaii 2021, which reviewed the classification and compensation schedules for this group of employees. And the conclusions of that study were that they were properly classified and properly compensated. And I'm available to answer any questions you might have.
Thank you very much. Thank you very much. Next, we have testimony with comments from Louis Salaveria, Department of Budget and Finance. Excuse me. We have testimony and support from the State Department of Defense. Testimony and support from the County of Maui Office of the Mayor. Testimony and support from County Council, County of Maui. Chair Alice Lee. Testimony and support from Aaron Farias, Honolulu Police Department. Please proceed.
Good afternoon, Chair Tarnas, Vice Chair Takayama, members of the Committee on Judicial and Hawaiian Affairs. I am Major Aaron Farias. The Honolulu Police Department has submitted written testimony in support of House Bill 1398. In summary, our 911 emergency response operators and police communications officers would be placed in a more fairer bargaining unit with more appropriate to their job classifications. In their current bargaining unit, they're generally amongst clerical staff. The training and skills of and duties performed by our emergency response operators and police communications officers are essential to our police department's public safety mission. They are critical employees, and they have to come to work every day like our police officers, and quite frankly, we would not be able to operate without them. Thank you.
Thank you very much. Next, we have testimony in opposition from the City and County of Honolulu Department of Human Resources. Testimony in support from the Maui County Police Department. Two testifiers from there, Susan Egdeman and Malia Johnson. We have testimony in support from Randy Pereira with the Hawaii Government Employee Association. Testimony in support from Iakea Tomslin. Are you on Zoom? Tomslin. Oh, you're here in person. Lucky us.
Yes.
The floor is yours. Please proceed.
Hi, my name is Lakia Chomslin. Good afternoon, representatives. I'm here testifying in support of this bill. I happen to be a telecommunication officer that everybody is referring to. I also happen to be a negotiator that has sit at the table and tried to negotiate the issues that are very specific to us for probably over 10 years. Some of the big key points that we have is 24-hour operations, the fact that the city, whenever there's an emergency situation, and most recently, almost every day there's an emergency situation, our contract kind of goes out the door and we end up having to get put under an emergency type order. And we can't negotiate at the table. We've tried numerous times to negotiate that stuff, the mandatory overtime. I know that people don't understand it because you're not in it. An example of this is from January 1st to February 28th of this year, there were 59 days. Out of those 59 days, only 7 of them, they did not order people to stay. When I say order people to stay, as of within those 59 days, 267 times they ordered people to stay and handle emergency calls. We're critically short-staffed. Currently with the pay that we are receiving, and I know it's a lot more than a lot of the other clerical guys, however, we're not able to recruit or retain. When I say that, I say we are getting 1 to 2 per year. We're senior heavy, so people are retiring double than what we're picking up. So right now, in my division, the Honolulu Police Department, I'm not talking about Maui, Kauai, or any other ones, we're about 44 vacancies, which is 1/3. The employees there want to ensure that we can negotiate these things so that we can bring in fresh employees in. It's getting bad. I cannot express to you guys how bad it is. Sometimes there's 2 people answering calls for the whole island in a comm center that takes 1 million calls a year. We want to make sure at the end of the day that we have somebody that's calm, cool, collected, and qualified answering these calls. Currently, not one person, not even a police officer, could step in a comm center and take these calls. We're concerned of what's going to happen in the future, and we're pushing that because a lot of the things that we've been asking, health and safety, mental health, release time for critical incidents, shooting stabbings, all that stuff, we're not getting the assistance sitting at the table. So we're just asking to get us moved so we can, especially collectively with all the islands and stuff, sit at the table and address all of our issues together.
Thank you.
And I'm here for questions.
Thank you very much. Next, we have testimony and support from numerous individuals, including Scott Sato, Michael Kim, Bonnie Kim, Jessica LaFale, Devlin Racadio, Vernette Logsden, Chelsea Irvine Pascua, Layla Batiz, Tracy Pelazar, Lindsay Kahuhu, Kuuipo Kanavalevale, Alea Amituatnai, Eddie Fujioka, Joy Maderos, and Darcy. Is there anyone else wishing to testify on House Bill 1398? If not, questions, members? I have a question first for Lakea. Thank you very much for being here, and thank you for doing this very stressful and essential job.
Yes, I've been there for 23 years.
That's amazing. The chief negotiator, Rena Hashimoto, referred to a report that was done some years ago. Are you familiar with that report?
It was done, I would say, about a year and a half ago. 2 sessions ago, we had a bill in, and then they asked for a study, so they did it. However, the study addressed the employees in their classification currently. So we're classified as clerical, we're non-first responders, which we have a counter bill in, waiting to be heard also. With that being said, not being a first responder, then this study was absolutely correct. However, it doesn't recognize what we actually do.
So would you consider that report as detailed and comprehensive as it should be in order to advise us?
I believe by what we are classified right now, because we're classified as clerical, we're not classified as first responders.
So it addresses that as clerical.
As clerical employees.
Does that study actually address the actual work that you do and draw its conclusions based on the actual work that you do in your job?
In my opinion, no. But if you look at the overall specs for what our job is, all of it just pushes towards clerical. It doesn't really take into account of, the stuff that we're doing, the shootings, the stabbings, ballistic missiles, tsunamis, earthquakes, hitting the sirens, working 24 hours. The weather gets bad. We're driving in super deep water to try and get to work because we're, set schedules. They don't change our hours because of whatever is going on.
Yes. Okay. Thank you very much. Ms. Hashimoto? Thank you very much for being here, and thank you for your work. You've got a tough job, too. I want to ask about this study, and I've heard these concerns, that it wasn't really enough detail to look at the actual work that this group does in order to provide conclusions that are really informative for us. How would you address that criticism of the report?
Well, first of all, I have the report in front of me, and it did look at multiple job classifications over many departments. We relied heavily on the other jurisdictions to identify the jobs that fell into this category. So it seems, by looking at it, it's not a lengthy report, but it does seem to be very comprehensive in terms of the jobs that it looked at. And like I said, we did rely on the expertise in the counties and in the state in order to identify and to assess the jobs. So it's somewhat challenging because, like the last testifier commented, these are unique jobs. They're only found in government, and of course we sincerely appreciate all the hard work they do and the unique challenges that they face. I think nobody disputes that. But when we look at comparisons, for example, in the labor market externally, they're very unique. And so we have to make comparisons between other jobs with similar characteristics, as well as we can use some mainland data when we can make comparisons, and then we have to extrapolate from there. So based on our review and the compensation analysis that was done in consultation with the other jurisdictions, we feel like they are appropriately classified. And if I can speak to the collective bargaining part, just because you become a new bargaining unit doesn't necessarily mean that any of those factors will change. In terms of, if you were to line up the different collective bargaining agreements, 90% of the language is the same across. It doesn't matter if you're Unit 3, Unit 4, Unit 2, Unit 1. They have a lot of common provisions, more so than they have just differences. So I would encourage this group really to talk to the city about specific concerns that they may have. Some of the other things that were mentioned were issues around recruitment, and those are specifically excluded from collective bargaining. So even if the employer wanted to negotiate recruitment, it's specifically prohibited under Chapter 89. So that, to me, is not the answer.
Understood. Okay, thanks. And then the other question I had is, are there objective criteria that you use or you would suggest be used to determine whether there should be a new bargaining unit? Are there federal criteria that would be used to make that determination? The reason why I ask, just so everyone understands, is if you were to read the Standing Committee report from the Labor Committee, who heard this bill first, that was stated in there as a concern, is that we need to have objective criteria for determining whether we should create a new bargaining unit. And I'm curious, from your perspective, does there exist both either at the state or the federal level objective criteria that one could use to determine whether there should be a new bargaining unit?
I am not aware of any objective criteria. I think when we look at what makes sense in terms of whether a group or of employees should be carved out and negotiate separately, it really speaks to whether the working conditions are so varied that we can't address those concerns under the provisions of the current contract. And I think in my experience, where we have seen differences, we've included specific provisions related to those groups of employees within their current contract language. Or we separate out the salary schedules, for example, if there's a specific market condition related to one group of employees, and we can't fill positions based on the salary schedule that's in place, then we perhaps would have a separate salary schedule for those individuals. You see that in Unit 10, where the EMT and the ACOs are on separate schedules and the healthcare workers are on separate schedules.
Just
So-
for those who are wondering, ACO is Adult
Corrections
Correction
Officers. Thank you. Yes,
Yeah,
that's
yeah,
correct.
okay. Okay, thanks. I ask about those objective criteria because the introducer of the bill was describing to me that there are objective criteria for determining whether we should create a new bargaining unit, but it's at the federal level. So that might be some additional information that would be useful as we consider this measure. But
Certainly.
I appreciate your responses. Thank you very
Thank
much.
you.
Are there any other questions, members? If not, oh, yes, Representative Ganadin, please proceed.
I don't want to mispronounce your name. Ms. Yakea? Just
Lakea.
Lakea. Oh, looks like I'm high.
That's correct, right?
Lakea.
Lakea.
Lakea. Well, thank you for your service. In your testimony, you discussed the kinds of issues that your office faced during COVID. What kind of calls did you have to take during that time?
During COVID, we took calls of all natures. People calling and reporting their neighbors as having more than 2 or 3 people with the city ordinance. They called about people in the parks. They called about parking. People, all of a sudden, were home and everybody in their neighborhood was suspicious. Every car was suspicious. People were just calling about, I'm on my way to work and the city is shut down, how come there's cars? And they were giving us plates and everything to deal with that kind of stuff.
So would you say that in addition to just being a resource for the police and the fire and other kinds of things, you're also doing a version of community counseling in telling people like what
Currently,
dangers
the
are?
HPD's dispatch center, we cannot refuse service to anybody. So if you're calling me about a low-hanging wire to somebody's dog looking at you, we actually have to take the call and address it. We don't have the authority to deny anybody.
Yeah.
During COVID, there were some very unique calls that I, in my 23 years, never experienced. However, the volume was beyond crazy. I cannot tell you the amount of calls that we had. It just was, yeah.
There's a developing vocabulary about trauma that service providers have. You know, counselors, therapists, attorneys, these kinds of stuff, and contact trauma. Have you seen that amongst your staff?
So I also, on top of what I do, I happen to be peer support for Honolulu Police Department. I actually have a whole bunch of different hats. But currently, there isn't anything for dispatchers. You can take a shooting, a stabbing, you can hear somebody's last breath that their husband just shot them while they're talking to us. And literally, their only recourse is to talk to a peer support person. And we have a critical incident. I fought a long time, along with a lot of people in the police department, to add the civilian staff. So that's the extent of what you get. If you go home and you can't sleep after that critical call or something, you're still expected to come into work or utilize your own sick leave. There is no protocol for any of this. So I can literally deal with somebody just shot their wife or beheaded their child or something. Hang up that call, I cannot take a break, and I have to move on to the next call. And the next person can be calling about a vehicle that was parked there for 1 year and AV and stuff, and you just move on throughout the day. There is no breaks to that because of our contract.
Got
We
it.
have 45-minute break
I
for
understand.
lunch, and we have 2 10-minute breaks, and you somehow have to get it together within those 2 10 minutes.
Thank you, thank you. Thank you for your service.
Thank you.
Thank you, Representative. Any other questions, members? If not, we'll move on. Thank you very much to the testifiers. Next, we have House Bill 1344 relating to anger management. Authorizes certain criminal offenders to be ordered by a court to undergo an assessment and then complete either anger management counseling or domestic violence intervention as part of their sentence. First up, we have testimony and support from the Office of the Public Defender. Welcome. The floor is yours. Please proceed.
Aloha, Chair Tarnas, members of the committee. My name is Darcia Forster. I'm from the Public Defender's Office, and I'm our family court supervisor. We did submit written testimony. We are in support of the bill. I do also want to clarify that I have been privy to the prosecutor's proposed amendments in their testimony. We've been sharing emails on this. We do not have any problem with the prosecutor's proposed amendments. I believe it may have been submitted as late testimony, but I just want to clarify we're okay with the amendments in their testimony. So in summary, the reason this bill is submitted is we created a domestic violence intervention working group that included service providers who provide domestic violence intervention classes together with the public defenders, the prosecutor's office, and members of the judiciary to discuss a problem that came up. The problem is that right now the law says anyone who is sentenced under certain specific statutes is required to take domestic violence intervention classes with no exceptions. What we've discovered is that domestic violence intervention classes really were designed for intimate partners. It is not appropriate for people referred to that class who are not intimate partners. For example, parents and children, brothers and sisters, siblings, uncles, and nieces or nephews, or grandparents and grandchildren. So the proposed amendments will fix that by making an assessment mandatory, and then the assessment will determine whether it's appropriate for you to do domestic violence intervention classes or anger management classes, depending on the nature of your relationship. And this will help improve completion, and it'll just be more appropriate level of care. So in summary, that's our testimony, and I'll be available for questions if you have any later.
Thank you very much. Next, we have testimony and support from Tricia Nakamatsu, Department of Prosecuting Attorney, City and County of Honolulu. Oh, or her representative, I guess I should say.
Thank you. Chair, Vice Chair, members of the committee, Deputy Prosecuting Attorney Mark Tom for the department. Yes,
Thank you for being here, Mark Tom.
Representative for Tricia. So, department is in support of House Bill 1344 HD1. The goal and purpose of HB 1344 is to ensure that individuals that commit these offenses get proper treatment. The department does appreciate the prior committee's amendments and hearing the bill and moving it forward. The suggested amendments that we have in our testimony, I believe that all the stakeholders share the same sentiment, that it's to also ensure that all individuals who commit these offenses actually get that treatment, and there's no ambiguity whether all individuals or just some individuals. So that's what those suggested amendments are, just to make clear any ambiguity that could be in the wording right now. So that's on page 1, lines 6 through 11, page 5, 8 through 13. Specifically, it's a person convicted under this section shall be ordered by the court to complete an assessment at any available domestic violence program and shall complete a domestic violence intervention or anger management course as determined by the domestic violence program. It's also an amendment on page 10, line 1 through 7, just changing counseling, anger management counseling to anger management course. Again, I also want to just thank, as Darcia indicated, the judiciary, the Public Defender's Office, the various amounts of service providers that sat down at the table and worked during off session to try to craft this language. We are here for any questions. Thank you.
Thank you, Mr. Tom. You did well, Representative Tricia Nakamatsu.
I tried.
It's not easy, I know, it's not easy. Thank you. Next, we have testimony and support from Angelina Mercado, Hawaii State Coalition Against Domestic Violence. Welcome, please proceed.
Aloha Chair, Vice Chair. I'm Angelina Mercado, Executive Director of the Hawaii State Coalition Against Domestic Violence. Thank you again for hearing this measure. We do support this measure because we think it's important to get the right people the right kinds of services that they need immediately. And we too conferred with the prosecuting attorney's office, and we agree with their amendments, clarifying, there was some clarification language in there, and again, making sure that people get the assessments from our qualified service providers. Happy to answer any questions you may have.
Thank you very
Aloha.
much. Next, we have testimony and support from Parents and Children Together. Testimony in support from Jill Araki. Please, come on up. Take your time, no rush, no rush. Take your time. We're grateful that you're here. The floor is yours. Please proceed.
Thank you. Aloha, Chairperson Tarnas, Vice Chair Takayama, and members of the committee. My name is Jill Araki, and I am testifying today as a private citizen in support of House Bill 1344. I have worked in the field of domestic violence for over 30 years, over 20 plus years with the survivors, and now almost 9 years with the offenders. I literally have helped thousands of people in Hawaii with this issue in their lives. I currently supervise a domestic violence intervention program, or DVI program, and I support this bill because it's really important to give domestic violence intervention programs the discretion to divert people to appropriate and relevant services. Domestic violence intervention was designed to challenge people who are using violence against their intimate partners. So a typical curriculum in domestic violence intervention includes challenging their belief systems on jealousy, on sexual violence, and consent. We talk about the effects of the violence on their children, and we also challenge their controlling and punishing behaviors on their partner while offering healthier alternatives. An anger management curriculum that's typical. We talk about stress management, we talk about emotional regulation, but we don't really challenge people with regard to their belief systems on their intimate partners in anger management. So currently, the criminal laws mandate everyone into DVI, regardless of the relationship with the victim, and DVI programs are forced to comply with that court order. We do get inappropriate referrals from other sources as well, but criminal court is the only place where it's mandated by law to order people into inappropriate services. We could use those valuable slots, to be honest, for clients who really need DVI, domestic violence intervention. What happens when someone goes into inappropriate services? Well, we had one client who violated his sister's restraining order, and he said, I don't know how to relate to this stuff because my incident was with my sister. He ended up terminated from our program for having too many absences and can face possible jail time because he was terminated in noncompliance from our program. Imagine what it must have been like for him sitting in a domestic violence intervention group talking about sexual violence when his victim was his sister. Another client ordered to domestic violence intervention for violating the restraining order on her auntie was terminated from our program for too many absences, and she too faces possible jail time for noncompliance. So several of the clients that I looked at with regard to inappropriate services were terminated for too many absences and dropped out of the program. So I really urge you to support this bill because it gives clients a greater chance of success if they stay engaged in relevant services. We want clients engaged in services for the safety of the community. This bill allows domestic violence intervention agencies to divert clients to relevant and appropriate services. And I do agree with the amended language offered by the prosecutor's office because the intent of the bill stays the same. Thank you for this opportunity to testify.
Thank you very much, and thank you very much for your leadership in this area. Okay, next we have testimony and support from Dana Keave and Penelope McKenzie. Is there anyone else here wishing to testify in House Bill 1344? If not, questions, members. Representative Ganadin, please proceed.
It's Ms. Forster with the, sorry. It's Ms. Forster with the Office of the Public Defender.
Yes.
Well, it's clear that defendants have been inappropriately sentenced to classes that weren't designed for the offense which they were found guilty of. What happens when a defendant does not comply with these classes after they're inappropriately sentenced to take them?
Well, if you don't complete the classes under the current law, then you face the possibility that the prosecutor's office will file what's called a motion to revoke your probation. And then you have to go back and see the judge. And there may be consequences that include jail time. There may be consequences that include extended probation. It may be that you're ordered to start from the beginning. And these domestic violence intervention classes can be like 25 weeks. And so if you've made it through 15 weeks of classes and then you get to that part where maybe the topic of sexual violence comes up and you drop out and you then have to go see the judge, you may have to start from the beginning again. So it could cost additional monies to defendants. So there are collateral consequences separate from just the possibility of jail time for not completing classes. So we really want our clients to succeed and do the classes and complete them, because once you complete the classes, then you can qualify to go back to the judge to talk about whether your probation can be completed. So that's my answer.
In your estimation, do these classes help predominantly men become better partners or parents?
So my answer to that is two parts. It is a misnomer that all the defendants in family court facing domestic violence charges are men. We have many people who are we have clients who are men, clients who are women, we have clients who are same-sex partners, we have clients that are involved in domestic living situations like platonic housemates. So it goes beyond just the husband and wife dynamic. So that's my first part. The second part is I do think these classes do help our clients to be successful. We are currently in the midst of a pilot project, so I'm very excited to see what the data shows. And I do think because we have so many clients doing the classes, this bill addresses inappropriate classes, but for the most part, these classes very much do help our clients. We support the classes.
Thank you.
Thank you, Representative. Other questions, members? If not, we'll go on. Thanks very much to the testifiers on this measure. Next, changing topics. We're moving on to House Bill 973 relating to hemp. Repeals the requirement for additional rules by the Department of Agriculture to address nuisance issues, including smell, noise, and excessive lighting arising out of the activities of hemp growers. First up, we have testimony from the Department of Agriculture. Welcome. The floor is yours. Please proceed.
Thank you. Aloha, Chair, Vice Chair, and members of the committee. I'm Leo Obaldo, Hawaii Department of Agriculture, testifying on behalf of Chairperson Sharon Hurd. We stand on our written testimony in strong support of this measure for the following reasons. There are already pre-existing regulations for noise, smell, and county ordinances on lighting. And number two, this is being perceived as duplication of function, regulatory function, and considered by the hemp growers as overregulation of the hemp industry. And third, I would say that the Department of Agriculture doesn't have any expertise in regulating health issues. So we would defer to existing regulations that are already in place. Thank you for the opportunity to testify, and I'm here to respond to questions if there are any.
Thank you very much, sir. Next, we have testimony and support from Hawaii Hemp Farmers Association, Ms. Gail Byrne-Baber. Please proceed, Gail.
Yeah, aloha, Chair and committee members. Thank you. Yeah, the Hawaii Hemp Farmers Association, of which I'm president, is in support of this bill. Just would like to add a little bit of data to our testimony. This was the result. These nuisance regulations were a result of an isolated incident on Maui that involved one farm and some neighbors. I've been to that farm. I was there last year. I can tell you that the noise, the smells that were coming off there the noise was less than a weed whip. I don't live there 24/7. I'm not involved in all the neighbor issues, but the result of this one isolated incident was that over 100 hemp farmers statewide were then put under unnecessary extra regulation, and the only farmers in the state that have to deal with these extra nuisance regulations. So, and previous to this incident, and still continuing to this day, there's been no other issue with any other hemp farm in the state, and most of the hemp farms are on other islands anyway. So it's about time to repeal this part of the rules, and we appreciate the Department of Agricultural support on this. Thank you. Aloha.
Thank you very much. And next we have testimony and support from Brian Miyamoto, Hawaii Farm Bureau. Testimony and support for Hunter Hevlin, Hawaii Farmers Union United. Testimony and support from Dana Kiave, and testimony in opposition from Carolyn Azelski. Is there anyone else wishing to testify on House Bill 973? If not, questions, members? Seeing none, we'll move on. Thank you to all the testifiers. Thanks for zooming in from Kohala, Ms. Gail Byrne-Baber. Appreciate that. Okay, we will now move on to the next measure. House Bill 1088, relating to declaration of water shortage and emergency. This amends the conditions, manner, and areas in which the Commission on Water Resources Management of the Department of Land and Natural Resources can declare water shortages and emergencies. First up, we have testimony and support from the Department of Land and Natural Resources. Kaleo Manuel, welcome.
Thank you, Chair, Vice Chair, committee members. Kaleo Manuel, Deputy with the Water Commission. We stand in strong support of this measure. This is our one and only administrative bill. Having dealt or continuing to deal with the Red Hill crisis as well as other emergencies that arise because of water quality degradation that then affects water quantity, the recommended amendments to this portion of the water code will help give the Commission the ability and flexibility to react and respond appropriately to deal with each of these situations as they arise in the future. And it distinguishes the difference between a longer-term water shortage that we can plan for and see via trend and data analysis, compared to emergencies that can happen, on the flip of a dime. So I'm here to answer any questions if you have any.
Thank you very much, and
Thanks.
glad to see you back continuing
Thanks.
in this position.
Thank you, Chair.
Yep, thank you very much. Next, we have testimony with comments from the Board of Water Supply. Welcome. Floor is yours. Please proceed.
Good afternoon, Chair and Vice Chair and members of the committee. My name is Kathy Mitchell with the Board of Water Supply. We stand on our written comments, but I'd like to highlight the second paragraph of our testimony, allowing CWORM to declare a water emergency.
Excuse me, if I could interrupt. CWORM is the Commission on Water Resource Management.
Yes, correct. Sorry about that.
That's right.
Allowing CWORM to declare a water emergency without a prior water shortage declaration by rule would appear to preempt and usurp the executive authority provided under HRS Hawaii Revised Statute 127A14C, which states, "The governor or mayor shall be the sole judge of the existence of the danger, threat, or circumstances giving rise to a declaration of a state of emergency in the state or a local state of emergency in the county as applicable. This section shall not limit the power and authority of the governor under Section 127A 13A5. We made other comments on other sections of the bill. Manager Lau wanted me to express to the committee that we are going to meet with the director and deputy director of DLNR on Monday.
Thank you very
Thank
much.
you.
Appreciate that. I appreciate your highlighting the major issues in your testimony.
Thank you.
Thank you very much. Next, we have testimony and support from Charles Ice. Is there anyone else wishing to testify on House Bill 1088? If not, questions, members? I have a question for Kaleo Manuel.
Yes, Chair.
So you have had a chance to look at the testimony from the Board of Water Supply and their concerns about this. Could you respond to those concerns?
Sure. Most recent concern about basically usurping the governor's authority, we don't agree. Like, the ability for the commission to issue an emergency will give us the authority to focus specifically on what's within the authority of the commission, which is to regulate water resources in the state. It would give us the flexibility to focus on specific provisions, orders, and decisions of the commission, and not carte blanche authority. Oftentimes, governor's emergencies suspend entire statutes as a whole, which still would result in us as an agency having to come up with the specific orders and recommendations to deal with such emergencies. So this just gives us the ability to act quickly. In reviewing the other comments related to modifications and revocations of permits under sections 57 and 58, at this point in time, the recommended amendments are specific to section 62 related to water shortage. This also falls under the overall Part 4 portion of the Water Code, which is overall water use permitting and regulations. So we feel that it is consistent with that portion of the statute. If in the implementation, and if this bill does go through, and there's a need to modify those sections, we can present those with amendments in future legislations.
Okay, thank you. And we had one other testimony. It was from Charlie Ice, who was a senior hydrologist with the Commission on Water Resource Management for quarter century, 25 years. He's not able to be here in person, but he made several suggested amendments. First one, if you could respond to him,
Yep.
He wanted to include an amendment to add the language that you had to adopt it by rule. What's your response to that?
So the primary purpose of this administrative bill is to not to give the commission authority to declare an emergency not by rule. It allows us to do that quickly, swiftly, and then also to rescind that quickly and swiftly. Currently, water shortages would still be required to go through rulemaking and to be rescinded via rulemaking. So we at this time don't believe it's consistent with the intent of what we're trying to accomplish.
And do you include public outreach and hearings in your planning process to come up with plans?
Absolutely, that's one of our core functions, especially if we can, and as the amended bill states, we want to come up with a statewide water shortage plan. In that process, we would do outreach with community, provide public information, and have a public hearing on the matter.
Okay, in his second amendment, he again wanted to say that the commission by rule could declare an emergency, and whether inside or outside of a water management area. So again, he wanted to do it by rule. What would be your response to that?
Again, our response and recommendation is for emergency purposes. We would recommend that we have the authority to issue that by commission order and action, not by rule.
Okay. The next one is that he wanted to add into a declaration of water shortage or emergency, and any measures pursuant thereto may be rescinded by the commission. Could you respond to that?
Yeah, so I think in most of his recommended amendments, as I read it, he lumped water shortage and emergency together. Yes. The purpose and intent of this is really to separate the long-term water shortages, which we can anticipate basically with our data sets, and those really immediate emergencies. By putting or there and connecting them, you do opposite of the intent of our bill or what we're proposing to do. So we're trying to make it explicit that sometimes emergencies do happen, as a result of shortages, but also emergencies just happen on their own outside of that.
Yeah, okay. And then finally, his recommendation that when a water shortage or emergency is declared, that you have to cause notice to be published in a newspaper of general circulation and on the website. What's your response to that?
If we go through an emergency order or procedure, we plan to have that in public session with the commission. Public will be able to attend. We want to modernize our outreach with community, so we're using our website and our tools available to do that. So we believe that the bill as drafted should support us to be good communicators with the community related to emergencies.
Okay, thank you for providing us your perspectives on the amendments that were suggested and the concerns expressed by Board of Water Supply and Mr. Ice.
Thank you, Chair.
Thank you very much. Any other questions, members? If not, we'll go on to the next measure. House Bill 1107 relating to commercial motor vehicle weight limits. It makes state law consistent with federal law regarding legal limits for gross vehicle weight and axle loads traveling on all public roadways. We have testimony and support from the Department of Transportation. Welcome.
Thank you, Chair, Vice Chair, members of the committee. The Department of Transportation stands on its written testimony in support of this administration bill. Basically, we have our commercial vehicle weight statute 291-35. Subsection 2 applies to only Oahu as it uses the term interstate. Another section or subsection 3, refers to highways other than interstate highways. So this bill just basically provides the definition that any public street or highway, just to be consistent.
Thank you.
Thank you.
Thanks very much. Anyone else wishing to testify on House Bill 1107? If not, questions, members? If not, we'll move on to the last measure, and that is House Bill 1109 relating to commercial driver licensing. This bill meets federal requirements on fraudulent activity relating to commercial learners permits and commercial driver's licenses. Our testimony today from Department of Transportation. Back up again. Thank you very much. Floor is yours. Please proceed.
Thank you, Chair, Vice Chair, members of the committee. The Department of Transportation supports this measure. Basically, we are aligning with the federal regulations from the Federal Motor Carrier Administration. I'm here for any questions. Thank you.
Thank you very much. Is there anyone else here wishing to testify on House Bill 1109? If not, questions, members? If not, thank you very much to all the testifiers on this. We're going to take a brief recess to assemble our members before going to decision making. Recess. Welcome back to decision-making in the House Committee on Judiciary and Hawaiian Affairs and our hearing. This is on our 2 p.m. agenda, March 2nd, Thursday, here in Conference Room 325. Thanks to all members for being here to make our decisions, and thanks to the testifiers for all your help today, because through your testimony we do a better job. So I appreciate you being here. Okay, first up we have House Bill 758. Relating to Native Hawaiian traditional and customary fishing practices. After hearing the testimony and having responses to the questions that we had from the Division of Aquatic Resources and their responses, I think it's best for us to defer this measure and ask the Division of Aquatic Resources to continue meeting with the Office of Hawaiian Affairs and try to come back next session with a measure that would meet both of your desired outcomes. And so this bill is not ready to move forward, but I appreciate the efforts of Division of Aquatic Resources and Office of Hawaiian Affairs to work together to try to address these issues. So we will defer House Bill 758. Next bill, House Bill 760. My recommendation is to move this out as is. I want to keep the defective date. We want to continue discussion on this. I would encourage the Division of Aquatic Resources to talk to their Fishers Working Group on this, a member of which testified in opposition, who had concerns. I think his concerns can be addressed, but I think you need to work with your Fishers Working Group to respond to any of their questions or concerns, so that as the bill moves forward into the Senate, hopefully if it passes here and passes on the floor, so that there can be, we can all be on the same page moving forward. But I want to keep the defective effective dates so that we know we're going to see this again. So that's my recommendation, move out House Bill 760 as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 760 HD1 passing as is. Chair and Vice Chair vote aye. Representative Ganadin.
Aye.
Representative Holt.
Aye.
Representative Hashimoto.
Aye.
Representative Ichiyama.
Aye.
Representative Villagan.
Aye.
Representative Kong.
Aye.
Representative Mizuno.
Aye.
Representative Souza.
Aye.
Chair, your recommendation is adopted.
Thank you very much. Next, we have House Bill 975 relating to sustainable agriculture. My recommendation, members, is to amend this bill so we pass out a House Draft 2. And I would like to adopt amendments to address the concerns expressed by the State Procurement Office. And I have prior concurrence from the chair of the Committee on Agriculture to do that. I'd like to keep the defective effective date so that we can make sure that we can have the State Procurement Office review the amended bill as it moves forward, and we make sure we address those concerns. So with those recommendations, members, do you have any questions or concerns? If not, Vice Chair for the vote.
Voting on House Bill 975 HD1 with further amendments, all members being present, anyone voting WR or no. Seeing none, your recommendation is adopted.
Thank you. Next, House Bill 970 relating to agricultural lands. Members, I think we've done good work on this, and the previous committee in agriculture did good work on this. I'd like to put in a clean effective date, effective upon approval, and move out House Draft 2 with that change. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 970 HD1 with further amendments, any members voting WR or no, your recommendation is adopted.
Thank you very much. Next, House Bill 841 relating to domestic abuse protective orders. I'd like to recommend making some amendments, just merely technical amendments that I'd like to include in there. And with that, I'd like to, it has a clean date, and I'd like to move it out as a House Draft 2 with those technical amendments. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 841 HD1 with further amendments, all members being present, anyone voting WR or no. Chair, your recommendation is adopted.
Thank you. Next, House Bill 1201 is a very interesting conversation and discussion with the Deputy Attorney General on this matter. I think that this bill offers a novel approach for citizens to have a private right of action if helicopters violate a noise standard that's in the state law, and I think that's worth pursuing because this is a problem that we experience throughout the state. The FAA said that they regulate air travel, and but they have not taken action to address these issues, where communities feel like helicopters are flying too low, flying over their homes, and being a public nuisance. So I'm willing to move this forward as a novel approach to try to address this issue, and we'll see where it goes. So my recommendation is to move it out as is. We're going to retain the defective effective date. It still needs to have a actual decibel level set in the bill. I was going to ask the Department of Health what that might be, but they're not here. So they will have to address that in a future hearing, and I will talk to the introducer of the bill to try to help make that happen. So with all of that, my recommendation is move it out as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1201 HD1 passing as is. Anyone voting WR or no? Your recommendation is adopted.
Thank you. Moving on to House Bill 1398 relating to collective bargaining. I am persuaded that this bill should move forward. I think that the emergency dispatchers perform a unique function, very different from clerical staff, and that it merits a separate consideration in terms of their employment agreements. And I think that the study that was done for the Department of Human Resource Development was not comprehensive enough in order to address the unique nature of these emergency dispatchers. And I also think that my understanding from the introducer is that there are clear objective standards that the federal government has for establishing new bargaining units. And so I will encourage the introducer and the representatives of the emergency dispatchers to work with the Department of Human Resources Development to try to get on the same page as this bill moves forward. I would like to retain the defective effective date and move this bill forward as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1398 HD1 passing as is. Anyone voting WR or no? Seeing none, your recommendation is adopted.
Thank you. Next, House Bill 1344 relating to anger management. I'm delighted to hear all of the consensus on this measure. I do want to adopt the prosecuting attorney's amendments, which everyone supports. I'd like to make some technical amendments, put a clean date on it, and move it out as a House Draft 2. Questions or concerns, members? Representative Gannon.
Just a note of thanks to the attorneys, the advocates, everybody who does this work. You're doing real peacemaking in our community. Thank you.
Thank you. I concur. Any other questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1344 HD1 with further amendments. Anyone voting WR or no? Seeing none, your recommendation is adopted.
Thank you. Next, let's move on to House Bill 973 relating to hemp. Again, we have unanimity among the stakeholders of the hemp industry and the Department of Agriculture. This is necessary and timely. I would like to propose that we put in a clean effective date, effective upon approval, and move it out as a House Draft 2. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 973 HD1 with further amendments. Anyone voting WR or no? Seeing none, your recommendation is adopted.
Thank you. Next bill, House Bill 1088, relating to declaration of water shortage and emergency. After hearing the responses from the Deputy Director of the Department of Land and Natural Resources, Kaleo Manuel, in responding to the concerns brought up by the Board of Water Supply and by Mr. Ice, I do think that their concerns are addressed in this measure, and I would like to move this forward. I want to keep the defective effective date because I want to encourage the Commission on Water Resource Management leadership to meet with the Board of Water Supply and Mr. Ice so that we can all get on the same page moving forward as it's being considered further in the Senate. And so with that, I'd like to move this bill forward as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1088 HD1 passing as is. Anyone voting WR or no? Seeing none, your recommendation is adopted.
Thank you. House Bill 1107 relating to commercial motor vehicle weight limits. I think this bill is ready to go. I'd like to put a clean date effective upon approval, move it out as a House Draft 2. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1107 HD1 with further amendments. Anyone voting WR or no? Seeing none, your recommendation is adopted.
Thank you. Next, House Bill 1109 relating to commercial driver licensing. I think this bill is ready to go. I'd like to amend it by putting in a clean date effective upon approval and move out a House Draft 2. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1109 HD1 with further amendments. Anyone voting WR or no? Chair, your recommendation is adopted.
Thank you. Next, we're moving on to House Bill 1241, which we had heard previously on February 28th at 2 p.m. on the 2 p.m. agenda. We deferred to today in order to work on the House Draft 2. As I said at that time in that hearing, we are working to incorporate the suggested amendments from numerous parties, including the Attorney Generals, the surveyors, the realtors, and the chair of Consumer Protection and Commerce Committee. Thanks to the great work of our House Majority Staff Office Attorney and our own attorney staffing the Judiciary and Hawaiian Affairs Committee. We have a House Draft 2 that I'm proposing to you. We distributed it to you in front of you at your place at the conference table here. What we've done is we've incorporated the amendments, made sure that they were not conflicting. We added to make clear what applies to the landowner where the survey is being done and what applies to the adjacent landowner. We made it clear that notice is required for the surveyor to the neighboring landowner, and that actually it lays out specifically what needs to be in that notice. And the neighboring landowner has the option to refuse entry, and that was clear. The Attorney General said we needed to do in order to make sure we didn't run afoul of a recent Supreme Court decision. We made it also clear that they could respond all the way up to 24 hours before the time that they were to do the survey, and we made it clear that if there is no response, then that the surveyor has the permission to enter. And as you know, as you can imagine, when you're doing a survey between two properties, sometimes you're actually going to be on the neighboring property. And sometimes surveys are done because there's a dispute between the two properties. And so that's why we needed to address this issue. So with those changes and the changes that are in this measure before you, and the other changes that we put in here is that we did change it to have a defective effective date, because I do want to make sure that everyone has a chance to look at these changes moving forward as it's being considered in the Senate, and that we can have a chance to look at again as this comes out of the Senate, if it does. So with those changes, I'd like to move out of House Draft 2 with the amendments as in the measure in the draft before you. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1241 HD1 with amendments. Anyone voting WR or no? Seeing none, Chair, your recommendation is adopted.
Thank you very much. Members, this has been a great first half of the legislative session. We've completed all of the consideration of the bills that we're going to before crossover. I really appreciate your hard work and with me on this. I appreciate all the testifiers that have helped us out, do a good job. With that, there's no further business before our committee today. This meeting is adjourned.